Hi, friends. Welcome back. My name is Carly, and I'm an employment attorney at the Manifest Justice Law Corporation. On this channel, we answer questions and share information about employment law. Today, I'm going to answer a question that I hear all of the freaking time from friends and family and people I know who have been involved in some kind of legal situation. They're working with a lawyer. The question is there such thing as too much evidence? The quick answer is no. No, 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 no. There is no such thing. Let's elaborate, especially in employment law, especially when your attorney is contingency based. If you are a contingency lawyer, you're not paying your lawyer out of pocket. You're not paying your lawyer by the hour. You're not paying the lawyer a fixed fee to get something done for you. You're paying them to represent you on an ongoing legal matter. In those situations, especially, there is no such thing as too much evidence. All of the time, like super frequently, I hear of lawyers who are telling their clients, like, stop, don't send me any evidence, don't send me any documentation, or I don't need that yet. I don't need that. Why? Like, unless it's completely irrelevant, completely not related to your legal matter, we want that. We want all of the additional context. We want the fullest picture that we can have so that we can advocate for your rights and we can, again, explain the full picture and the full impact of what's going on with you and what you've experienced. If we don't have the full context, we're not going to be able to represent you and your interests to the fullest degree that we probably should be. We want that evidence. Also, we are getting paid at how well we can represent your claims and argue on your behalf. So we want all of the evidence. We want all of the information. We want to see it. We want to go through it. We want to review it. And then we also want to have the ability to say, this is what we think is the most impactful and helpful. And these are the most harmful parts of the documentation or evidence that you've given us, or the least helpful. So we'll be able to use our own discernment when we see the evidence and the documentation that you provide us, but we absolutely want to see it. We should be wanting to see it. If you have an attorney, a legal team, a law firm that you're working with on an employment matter, and they're telling you that you're sending too much evidence, or that they don't need to see it, or that they didn't read it, or if they're indicating to you in other ways, i.e., not remembering, not talking to you about it, not asking you questions about the documentation that you have sent in, that is deeply, deeply, deeply alarming. Like, that scares me. That gives me like heart palpitations. That scares me. I want your attorney to be so invested in what's going on with your legal matter. I want them, and again, maybe if you call them on a random Tuesday afternoon and ask them some questions about some documentation that you sent in 2 weeks ago, they may not have it fresh on their brain. I'll give them that, right? We could be in the middle of working with a different client, another case, other facts, and sometimes the facts can get like mixed up and interwoven. That's okay. That's understandable. But they should be able to look up your case, look up your matter, do a quick review, and be like, oh yes, yes, yes. Oh, those 50 documents you sent in a couple weeks ago. We haven't taken a look at it yet because X, Y, and Z, but we plan to on next Thursday. Or we have taken a look at it, but we are still like missing some information. Or it didn't open, so we need you to send it again, or whatever it is. But they should have some information and be able to engage with you on the documentation. The answer is no. There is never too much evidence you can send in. There's never too much information you can tell us. We want to know. We want to have a full picture. We do not want to be embarrassed sitting in front of the opposing counsel or in front of a judge and not knowing something. We don't want to be surprised with some new information that we didn't know but should have known. We don't want to be thrown off by information that we didn't know and should have known. We don't want you to know that we have clearly not read the information, still not know what's going on. We don't want to have not done the work that we needed to do, and then you figure that out, and then you don't give us the quick download. If there's something, if I'm in a deposition and I have missed something or forgotten something that's really important for my client's case, I rely on my client to be in this with me, to be participating in their representation, and to let me know really quick. Write me a quick note, pull on my shirt, whatever it is. Let me know that, oop, you need to say this, or oop, you forgot this. Forgetting, not having it fresh in your memory, that's different from saying don't send it, saying we don't need it, saying it's irrelevant, saying you don't look at, like, those are all very different things. Your attorney doesn't necessarily need to remember every single piece of documentation that you've sent in and what it all meant and how it helps your case, but they absolutely need to review it. They absolutely need to review it. And if it's not your attorney, it needs to be the paralegals or the legal assistants, but someone in the legal team needs to be looking into everything that you send and sorting it and organizing it for your case appropriately. So All the time, I see attorneys turning their clients away or dismissing their clients or invalidating their clients or making their clients feel irrelevant or like they are doing too much for asking simple, basic questions or for trying to hand over the documentation that they have so graciously and so considerately put together for us. That should not be happening. If your attorney is saying that to you, you could tell them to go fuck themselves. Or if it's already at that point, or you could also ask them, like, "What's going on? Why haven't you read this yet? Why haven't you looked at it? Why are you saying it's irrelevant? Why are you saying you don't need this?" And ask for more information. Also, maybe it's a note to take, and maybe that's an indicator that you could look for, or maybe beneficial to look for some different legal representation. Mackenzie agrees. Okay. She's agreed. She's tired. Look how tired. She is so tired of attorneys who do this. And she's gonna take a little rest. She's gonna take a little rest. I'm gonna take a little rest because now you guys know. Now everyone here knows. Now you all know that is not too much. You are not too much. You do not have too many questions. There's no such thing as too much evidence. There's just that doesn't exist. You're not too much. You're not giving too much. You're not asking for too much. You're not doing too much. You are not too much. Your attorney might be too little, but you are not too much. Hopefully, this was some helpful information. Hopefully, this was very empowering. Hopefully, this helps you get paid. And if this was not a helpful video, or if it inspired more questions from you, or if you just want more information on this, please don't hesitate. Feel free, comment below, let me know, and I will make another video and try to do better. If this was helpful for you and you found it was beneficial, then give me a like. Let me know. Let me know that as well. You could also leave me a comment, give me a share, let your friends know. Make sure they are aware that they're not too much. Do what you need to do. But at the end of the day, just take care of yourselves. Remember, everybody works, but not everyone is safe at work, and I wanna make sure that you all know the difference. I hope you all have a good day. Take care of yourselves. Bye. We're gonna go take a little nap, rest from the bad attorneys. Okay, bye.